everyone. We may have some additional folks who come in as they are able, but I'm very excited to be able to present today Kyla Lee, who is, I think, as some of us know, one of Canada's leading experts in impaired driving law and administrative driving prohibitions. She also has a very amazing TikTok channel where she does some great access to justice work, educating the general public about DUI law in Canada. So she's here today to kick up her access to justice um, education with respect to, instead of just kind of the baseline access for the everyday person, with a bit more specialized knowledge to share with us, the lawyers who practice in Nunavut. So a bit more about Kyla. She practices at Acumen in Vancouver, and she's appeared at all levels of court in BC, including at the Supreme Court of Canada in Ottawa. She's done a lot of IRP defense kind of in Western Canada generally, and she's defended hundreds of thousands of driving prohibition cases, but also helped to shape the understanding of impaired driving law for the wider legal community. So I'm really pleased to have her here and to have this opportunity to learn, given the unique challenges in Nunavut and how, roadside testing devices are not super well used in the territory. They're not really frequently used in most of the communities we have, but they are becoming more and more prevalent. And with that, we do need to have our own individual competencies at a good level in order to defend our clients. So thank you very much, Kyla.
Thank you. I don't know about hundreds of thousands, maybe just thousands. Definitely more than 10,000, but I stopped counting at that point. Thank you for having me. I'm very honored to be here. I'm just going to dive right into it because we've got an hour and I made like, I don't know, 90 slides because I got overexcited. So the PowerPoint will be made available afterwards. So I'm going to just like power through some parts of it and pay more attention to some of the more specific things related to roadside testing. So I'll share my screen here. Somebody shout out if you can't see the screen. Good. Okay. All right. So breathalyzers and blood tests. The first thing I guess I'll say is with respect to the different types of tests that are out there, we have the mandatory alcohol screening, you've got the suspicion-based ASD, the SFSTs, the saliva tests, the breath demand, the DRE demand, and the blood demand. And I didn't write urine demand there for some reason, but there's also that. So there's all sorts of different types of demands and different types of tests that can be done, which makes it important to remember what you're dealing with when you're dealing with them and understand the different rules around when each can and can't be used and the things that can affect the validity of each of them. So with mandatory ASDs, those are done under Section 320.27 sub 2 of the Criminal Code. There's a number of prerequisites, and these are sort of like if you have a file where the officer actually uses the roadside screening device, these are the big things that I look for first in my file is did they make the demand immediately and did they conduct the test immediately after the demand? Were they acting in the lawful execution of their duty in the first place? So if they've unlawfully pulled over your client, then the demand is also not valid because the criminal code requires that the officer be acting lawfully before they can make the demand. And the officer must be in possession of the ASD. That doesn't mean like directly in their hand, but in their in their person or their police car in their immediate vicinity. Basically the same way possession would be construed if your clients had drugs or guns. And the demand must be given to a person who is driving. And is driving, we're going to talk about a little bit because that has a bit of a different definition than what we see for the suspicion-based ASD demands. So that's a very blurry picture. These are demands that are read when the officer has a reasonable suspicion that a person has alcohol in their body. Just like with the mandatory demands, the suspicion demand and the test must be immediate, but the sort of clock starts ticking for immediacy for the demand from when the officer forms the suspicion. So rather than from the outset of the interaction, it's then from when the officer formed the grounds to read the demand. The officer must have a reasonable suspicion that there is alcohol in a person's body at the time of driving. So you can't, and we see this often where police will show up on somebody's doorstep. They've had a report of an accident, they've left the scene, or single vehicle left their car in the ditch. I imagine that probably happens a lot up north. I know on my Yukon files it's common. Um, and so they have to have a basis to suspect the alcohol was in the person's body when they drove, not when they knock on their door and they've been drinking at home or whatever. So make sure there's some evidence that the officer's relying on to allow them to conclude that. And then they also must have reasonable grounds to suspect that the driving occurred within the preceding 3 hours. So if the accident happens at 4 and the officer's dealing with your client at 8, they cannot make a suspicion-based ASD. They can't actually make an ASD demand at all. It has to be within 3 hours of the time of driving or the time the officer suspects the driving occurred. And a lot of times you'll find officers do not turn their minds to that in accident cases. And especially if you have remote areas where somebody may not have been seen for a long time, that's often a very good way to challenge the validity of the demand. So is operating, and the 3 hours is different. Obviously, the 3 hours is clear in its definition, but is operating means the person must actually be in care and control of the motor vehicle at the time that the demand is read. Now, that doesn't mean like, the officer pulls your client over, they get them out of the car and they walk them back to the police car and no longer are they operating, but they had to be just operating the vehicle, like at the time of the stop. They can't do a mandatory demand if they show up on somebody's doorstep or stop them walking down the street after a report or something like that. And this is important because this is operating language, used to be what was used in the criminal code when the ASD demands were first brought in. And then they changed it to the preceding 3 hours to facilitate officers using it more effectively at accidents and after reports. So because Parliament deliberately chose language that they knew from before had a certain meaning, that supports that it doesn't incorporate this preceding 3 hour requirement. And in my experience, a lot of Crown haven't thought that through. And that within the preceding 3 hours, it's only required that they have a reasonable suspicion that the driving happened within the preceding 3 hours. So speculation isn't enough, but they don't have to have grounds to believe it or anything. Basically, the evidence needs to reveal that they turned their mind to it. There was some basis for the conclusion, and that's enough. It doesn't have to be anything in particular. SFST and saliva demands are basically just like suspicion-based ASD demands, so we'll skip past that. Same requirements, just for drugs instead of alcohol. Immediately, the leading Supreme Court of Canada decision is Bro, and basically it says that it's both implicit and explicit that immediacy exists, implicit with respect to the demand, explicit with respect to the timing of the sample, and the only exceptions are two things, which we're going to spend a little time on. Number one, the operational requirements of the device, and number two, unusual circumstances. And that does not mean administrative convenience. There's a really great decision about 2 minutes of delay, which I love, from the Saskatchewan Court of Appeal, where they found that that was 2 minutes too long for an ASD demand because the officer decided to write the traffic ticket before reading the ASD demand. He's going to have to give the traffic ticket anyway, and he thought, well, we're waiting for mouth alcohol. And so I'll write this traffic ticket while I'm waiting. And it took 2 extra minutes. And the Saskatchewan Court of Appeal said, nope, that was administrative convenience. He should have written the ticket after doing the ASD test and only waited exactly the 5 minutes that he needed to wait in those circumstances. So love that decision. It's cited in here later. Um, and there's no exhaustive definition of what unusual circumstances are in Bro, but it does get more clear in the subsequent cases from the Saskatchewan Court of Appeal, who, as far as I'm concerned, are doing the Lord's work. And so they've basically broken it down to officer safety or other types of operational issues besides residual mouth alcohol or contaminants. And these are the three cases that you want to look at for what isn't unusual circumstances and how long delay can be when it comes to alcohol elimination. Reasonable suspicion, you're basically going to look for in the impaired driving area. I mean, everybody knows what reasonable suspicion is legally, but in the impaired driving arena, reasonable suspicion of alcohol in the body is going to be pretty much unassailable if the officer detects an odor of liquor on the person's breath, or they admit to recent consumption of alcohol. There can also be physical indicia coupled with evidence of alcohol consumption, but those are really rare cases. So if you have somebody stumbling and slurring, and there's liquor containers in their vehicle, you're probably going to have a good argument, as opposed to if you have somebody stumbling and slurring who also has a smell of liquor on their person but not on their breath. Then you might have that, physical indicia coupled with evidence of alcohol consumption. Um, and admissions, you also have to bear in mind that the admission actually has to be something that would cause the officer reasonably to suspect the alcohol remains in the person's body. If I say to the officer who pulls me over this morning, I had my last drink at 9:30 last night. It was about 12 hours ago, but it's not, that's not going to give them a reasonable suspicion I have alcohol in my body now. It has to be something that actually would lead to the officer concluding that. And it's always going to be case by case. Generally, the law in BC on this tends to be starting at 3 hours or more. You're going to get into well, hold up, what else did you know? And of course, if there's an odor of liquor on the breath coupled with the admission, it doesn't really matter what they say. So, pay attention to that. Also, if there's indicia and an admission, but the admission is longer, that might get over the hurdle. But, if it's just the bare admission, anything over 3 hours, and I think you can argue that uh, it wasn't something that gave them a reasonable suspicion. Also bear in mind with respect to odors, distinguishing the source of the odor. You'll see a lot in officer notes, in their handwritten notes, that they'll write down odor of liquor, but not the source, if they write it down at all, which more times than not, they don't. And if they don't write down the source, great fodder for cross-examination to show that they're just saying later that it was from the breath and not that it was from the breath at the time. And if there is an odor sort of in the vehicle or on the person of the individual, if there's some explanation for that, like open liquor containers in the vehicle, or the person's got a big red wine stain on their shirt, then the officer also needs to take that into account. But if they don't know, they don't need to consider factors that weren't, known to them or believed by them at the time. So these are a couple things I always suggest considering when challenging the suspicion for the roadside breathalyzer. Were the grounds recorded in the notes? How specific is the note? Did other officers or witnesses also observe these things? I'm actually dealing with a case I trial later this week on this question of an odor of liquor that one officer says they detected and four civilians were asked specifically and did not detect it. So, well, who's really wanting to see it in that circumstance? And also, is there an explanation revealed on the evidence for the odor? This is where I'm going to spend a little more time, which is the operational issues for the ASDs. So because the ASD functions essentially as the gateway to reasonable grounds for the breath demand or the blood demand, although you're really not going to get a blood demand if you're doing an ASD unless more comes into play. These are the things you really need to focus on, because these are the things that the officers trained about and know about that should either cause them to delay or cause them not to delay, as the case may be. So all of these things can affect the test result. And actually, there's one thing I missed on here. So the first and the obvious one that comes up most often, we're talking about residual mouth alcohol from recent consumption of alcohol. So if you have consumed any alcohol or alcohol-containing product, Within 15 minutes of taking the roadside breathalyzer, the officers are trained that that can cause falsely high readings. There's scientific articles out there that suggest it can actually be closer to 30 minutes if the person doesn't like talk or open their mouth at all. So if they're alone in their car when they leave the bar and drive home for half an hour, it's probably still going to be some residual mouth alcohol, but 15 minutes is the accepted practice. So that's what you're looking for. When it comes to 15 minutes, you want to be very careful about those circumstances where your client says something about when they last consumed alcohol and what they say. So I get cases often where people are pulled over, they're asked when they had their last drink, and they're so honest. And they say something like 5 minutes. And a lot of officers will go, okay, well, 5 plus 10 makes 15. And so they wait 10 minutes. And that's not the correct approach. They are supposed to wait the full 15 minutes in those circumstances. And that's because obviously, the driver doesn't know the significance of mouth alcohol unless they pull any of us over now, because now all we know about it. So they don't, they're not thinking 5 minutes exactly down to the second. When we say 5 minutes, we mean, yeah, it's going to be a very short period of time from now. When did I log onto the Zoom? 5 minutes before it started. It wasn't 5 minutes exactly, but that's how we talk, right? That's how we normally speak. So you would want to wait the full 15 minutes because of that inherent margin of error in an estimate. The beauty of this, though, is that you can use it both ways. You can flip it both ways because if the officer does wait the full 15 minutes, sometimes you can successfully challenge that if you get them to agree in cross-examination that they had a basis to believe that the 5 minutes was probably an underestimate or was not accurate. Like the person was just lying about 5 minutes to buy themselves time, which some very experienced people will do. So pay attention to that because every once in a while you can actually use that to create delay that invalidates the ASD demand. But most of the time you're going to have the officer just adding up the time and waiting, and that's not good enough. Mouth alcohol, though, can also come from any other source that contains alcohol. So you don't just have to have like recent drinking. I did I think my most viral TikTok video was me eating sushi, and I like smothered it in soy sauce and took a bite and then blew into the ASD and got a reading. And I mean, people were just arguing in the comments, which I loved. Um, but that's the thing, right? There's all these things that we consume that actually have alcohol in them that we don't think about. Energy drinks. A lot of energy drinks contain trace amounts of ethanol, kombucha, and those, fermented drinks. There's a lot of like probiotic sodas and stuff now too that also have some fermentation and then contain trace amounts of ethanol. It's not listed on it, but they actually do cause false readings. And then you have, classic ones that people know about, like mouthwash and breath spray and those types of things. So anything that contains alcohol, you want to really like grill your client on any of that and whether any of that would have been made aware to the officer. Was the mouthwash bottle sitting in the center console of the car? And then you also have mouth alcohol that you can bring up from burping, belching, vomiting, or regurgitation. And so if you have undigested alcohol in your stomach and you burp, belch, vomit, or regurgitate, then that can cause a false reading. The beauty of the suspicion factor is that you don't have to establish for the purposes of challenging an ASD, unless you're in an administrative scheme that depends on ASDs, you don't have to establish that there was undigested alcohol, just that there was burping, belching, vomiting, or regurgitation. And then it falls to the officer to wait 15 minutes from when those things are observed. And then you have objects in the mouth, smoking and vaping. All of those require 5-minute waits. The reason for smoking is because the chemicals in the cigarette smoke will actually react on the fuel cell inside the roadside device, and that can lead to false readings. Vaping, they did an experiment. At the RCMP lab in Vancouver. No, Green Timbers. I don't know, one of them, one of the RCMP labs. And they did it because I found a bunch of scientific articles out of the States that were taking vapes and actually like pouring out the vape juice and then using headspace gas chromatography to see if there was any ethanol in the vape juice. And like 51% of vapes had undisclosed alcohol as an ingredient. So the RCMP went and did an experiment because I was using this as an argument in my administrative cases. And they found that there was residual mouth alcohol contamination from vaping that typically dissipated within 3 minutes. Their experiment, though, is like wildly flawed. Like somebody was sneaking puffs from their vape when they were supposed to be in the deprivation period, which is like so true of vapors. Um, and they were also like they weren't using the vapes like you would normally vape. They were like putting the vape liquid in their mouth. Like it was weird. So anyway, their conclusion is 5 minutes. So that's basically what's accepted now, even though I think it should be 15 and the literature out of the States says it should be 15. That's what you're going to get. And then temperature is a big issue. So all of the roadside devices have an operational temperature range. And if you look at the Alcohol Test Committee recommendations, there's also an optimal use range. And it'll never come up where I live. But where you live, you may have days that it is much colder than the manufacturer says the device should be used. So there's two temperatures, the external temperature, which, you got to get real cold for that to be a problem, but also the internal temperature of the device. And officers will, they'll keep it in their shirt pocket, or they'll keep it like next to the heater in their car to keep it within the optimal range. For the one we use in British Columbia, the AlcoSensor FST, it's anywhere from -5 to 55 degrees Celsius. So it's a very big range. But if the temperature is outside that range, then it can produce false readings. The other thing about temperature is that temperature can also work from within your body to falsely elevate the tests. So if you have somebody whose mouth is a hotter temperature than it would ordinarily be, then that can cause false readings. And that's where you get these waiting periods that are required for gum, candies, mints, that type of thing. If they contain alcohol, it should be 15 minutes, but if they don't, it's 5 minutes because having an object in your mouth will raise your mouth temperature. It's like your basic friction, right? You're moving it around in your mouth, you're creating heat. And it's raising your mouth temperature, which is then leading to falsely elevated readings on the device. And then we have hand sanitizer, calibration and service issues, and functionality issues as well. Hand sanitizer being a thing that can trigger readings just from the ambient air. So I do have a couple slides on these issues. So the best case that I think exists on the discussion, well, it cites a case called Mastro Martino from Ontario, but this is the one we use in BC, is a case called Seavright. And it basically sets out like a number of principles that officers have to guide themselves by when they're administering the roadside breath test to make sure that it's not going to be elevated by residual mouth alcohol. And it really boils down to whether there's credible evidence that would cause them to doubt the accuracy of the test if the test is administered without a brief delay. And Seabright gives some examples of what credible evidence is, like the person just left a bar, or the person had open liquor in their vehicle, or what the accused says about recent consumption and whether that's believed. There's a really funny case in BC called Polischuk, where Mr. Polischuk says, "Oh yeah, I just had a beer." And the officer goes ahead and administers the test right away. And the lawyer very cleverly cross-examined the officer on the meaning of just. I just had a beer, could be I only had one beer, but it could also be I literally just finished my beer a few minutes ago. And so the officer needed to wait. And he won on the definition of just, which is like just one of the beautiful things about being a lawyer. And so that's credible evidence. Leaving a bar is also a big one. We know, if your client's pulled over coming out of the parking lot of a pub and they say, "Oh no, I haven't had anything to drink," most officers are going to think that's probably not true. So there's a number of cases that talk about leaving a bar in the context of all of the other evidence. So again, it's credible evidence to cause them to doubt the accuracy of the test result. For burping, belching, vomiting, regurgitation, the officers are trained to observe people for this, but it's not required that they actually do it. So if you have somebody who says, my last drink was 5 minutes ago, the officer waits 15 minutes to administer the test, but doesn't go like this. Well, you can't see me because of the slides. Doesn't, stare into their eyes and watch them for those full 15 minutes. The fact that they didn't pay attention to this doesn't affect the validity of the ASD. It's only if they see it or if they have reason to believe that it was occurring. And so sometimes if you get video, I don't know how widespread dash cam usage is or body cam usage is in Nunavut, but I know the RCMP is rolling it out across Canada, so eventually it'll be everywhere. The you can sometimes see people do things that look like burping that the officer, you could get them to agree they would have seen it, like they'd put their hand over their mouth to coverly polite their burp. They kind of jerk their body, something like that. I have had them agree that that could have been a burp and that they would have seen it in cases. So just look for your client making movements that look unusual when the officer would have been observing them, but maybe not observing them so closely. Objects in their mouth. The officer is supposed to wait, like I said, 5 minutes, but they also need to, like Seabright says, turn their minds to, is this something that could contain alcohol? And most officers will agree that that like gum and candies can contain alcohol because on their training course, I know one of the things that they do is they pop a Mento in the trainer's mouth, like a Mentos mint, and then they wait a little bit for the sugar alcohol, and then produce a reading on the basis of that. So they know that some of them can contain alcohol and different types of alcohol. So if you get them to agree that they know that and that they didn't take any steps to check the ingredients or ask to see the packaging, which I've had officers do, then you have a basis to say, well, 5 minutes actually wasn't enough. Was it, officer? And when it comes to the mouth temperature waiting, that's only 5 minutes for mouth temperature to stabilize. Smoking and vaping, I think I already covered this. So temperature, the reason temperature is important is because all breath testing, no matter what instrument or device is being used, operates on the same scientific principle, which is known as Henry's law. It's at a given temperature, the saturated vapor above a solution contains a concentration of solute proportional to the concentration of solute in the solution. And I know we all did not become lawyers to do that much science to know what that means. If you think about salt water and you boil it, as you're doing that, you're going to have a proportional concentration of salt in the steam above the water as you're going to have in the water. So it's the same for breath testing. What's in your blood is going to be proportional to what's in your breath because in your lungs, you've got these little alveolar hairs that are connected to the part of the lungs that have the closest proximity to the breath samples, and there's off-gassing from your blood vessels into the lungs. Super cool. And so the breath testing operates on the principle that 2,100 parts of your breath is equivalent to 1 part of your blood. And that's why temperature problems can cause faulty readings because this rule is temperature dependent. So if your client is sick, if they have a fever and if the officer pulls them over and they're, coughing and sniffing and displaying illness symptoms, that's great because you can put the temperature thing to them. They are trained on this. They will not remember it from their training. You'll have to get their manual and put it to them, but they are trained on this. So they're supposed to know this. But they also didn't become police officers because they loved their grade 7 science class. Hand sanitizer has been one that never used to come up until the pandemic. And then during the pandemic, a bunch of scientists did a bunch of experiments where they put hand sanitizer on and then did a breath test without even touching their face or anything. And the ambient alcohol wafting up from the hand sanitizer, because usually it's 99% ethanol, was enough to contaminate the result just from a person breathing it in. So if you see an officer put on hand sanitizer or something on their hands, or if your client had hand sanitizer in their car that would have been visible to the officer, if there's a strong alcohol smell about them, that can cause false readings. It can also happen with perfumes and colognes and body sprays. So pay attention to that. Gucci guilt will make you guilty, which I know because I I blew an ASD sample after putting Gucci guilt perfume on. that somebody had given me, and I thought it was funny because it was called guilt. Um, Calibration and service issues. So every device is sometimes going to be a little bit different. But right now, and this also might be changing very soon because there's a new device being rolled out across Canada. The RCMP is going to one device for the whole country, the Draeger Alcotest 6800. So ASDs are checked for calibration every 28 days per the Alcohol Test Committee recommendations, and they're programmed not to accept a sample beyond the 28-day calibration period, but I've seen them do it. So if it's not properly calibrated, it's not going to be working properly, which means it's not necessarily going to do what it's supposed to do. And that's also because when the officer does the calibration check, they program the next date into the device. So if they program it wrong, it's also not going to work. So the devices also have service expiry dates. So they're checked for calibration every 28 days, recalibrated if they're out. And then once a year, they go for annual servicing. So they have an expiry date for the servicing as well. So you can always look at the two expiry dates. You can request disclosure of the calibration records for ASDs. There's no prohibition on that in the criminal code. And even the devices itself, the officers, they'll have a sticker on the device where they can print the dates. So every officer operating the device would know the service and calibration expiry dates. And they also, when they calibrate them, they use a canister, this is the canister here, of pressurized ethanol. And so it's meant to simulate the way that the alcohol molecules will behave in a breath sample when you put it into the device. And then it's adjusted. So you don't see it in the image here, but there's a little like attachment that they put on the canister that measures the barometric pressure. And then it adjusts what the expected reading is for the barometric pressure. So the higher above sea level you go, the lower the expected reading is. The canisters used across Canada are all 82 is the expected reading at sea level. So the purpose of the ASD is to give the officer grounds. This McGuire case out of Yukon is really good because in the trial level decision, the judge did a very thorough canvass of all of the law across Canada in relation to whether an officer can rely on the ASD if there was a contaminant they didn't know about. And I think it was smoking in McGuire. And the trial level decision said no, ultimately resolved this conflicting case authority, and Mr. McGuire appealed, and the Court of Appeal also agreed with the trial level judgment. So basically, they have to know. So you have to get them to admit they were trained on it or they knew about it from watching something on social media. There's lots of like breathalyzer demonstration videos out there. I'm not the only person nor the person who invented doing it, or talking to their colleagues about things that happened. So you have to get them to agree that they knew it in order to challenge it, or that they should have known it based on their training and show what their training was. And that the other thing that you can do to challenge the ASD is look for the status messages to see if the device was malfunctioning. Those are things the officers should be able to interpret. And oftentimes they write them down wrong or they don't write them down at all. And then you can say, well, you didn't know, you got an error, the sample wasn't accepted, but you don't know why. You can't say why, what it was that was done by your client, or whether it was a malfunction of the device that might have affected the reliability of the reading. So anytime you get an ASD case, make sure to get the manual. If you don't have the manual in your law library, you can message me. I might have it. And if not, you can get the Crown to give it to you. They'll sometimes say, oh, it's copyright. And that doesn't apply to disclosure. That's not how that works. And you can FOI it. So even if they won't give it to you that way, you can get it from FOI, which is where I got all my manuals. So on the AlcoSensor FST, these are sort of the status messages you would get on unsuccessful attempts. And the first one there, flow INS, I bet you're thinking, oh, that probably means flow insufficient, but it doesn't. And that's the most common error I see that helps me to invalidate the officer's reliance on the device. because they think that means flow insufficient. It actually means the breath flow rate is inconsistent. It's a I don't know why they didn't do INC. That makes a lot more sense, but I didn't program it, and I'm going to take advantage of their bad programming. And you'll get 3 of those messages followed by a blow void on the final attempt. And then RFI void is a really interesting thing. So these devices are designed to be immune to radio frequency interference from Wi-Fi signals and radio signals and all the other things that are flying through our air. But they're not. And so it'll give an error reading sometimes based on detecting radio frequency interference, which just proves they're not immune. But it also might not detect the error. So you can ask the officer about their cell phone and whether they had their duty phone and their personal phone, whether their radio was on, whether they had their radar turned on in their police vehicle, all of those types of things that can interfere with the results. And the RFI void readings also are good because a lot of officers don't even know what they're supposed to do when they see it. What they're supposed to do is turn off the source of the interference, turn off their phone, ask the person they've detained to turn off their phone, turn off their radio, whatever it is, to stop the interference. But usually they either replace the device that doesn't solve the problem, or they change the mouthpiece. I don't know why they think that those are the solutions, but it's almost invariably that's what they do. And then you also have a reading that'll give like a null fail or some indication, usually a null or null void or null fail. And that is when the device, when it's doing a blank check, so it checks that it has no alcohol remaining on the fuel cell prior to having the first sample provided. So if it fails that blank check, it'll give a null fail reading or some type of null reading. And that means there's alcohol left over there. And so then you can challenge the officer on relying on it if they're, using the same device multiple times, your client's having trouble blowing, there's alcohol buildup in the mouthpiece and they're not changing the mouthpiece, and then they get a null fail. It doesn't come up that often, but when it does, again, they usually don't do what they're supposed to do. They just wait a few seconds and try it again, and that's probably not going to be enough. I don't know why I kind of duplicated that information. So this is my cross-examination question that I ask in every single case where an ASD is used. I actually had a file last week that I resolved where I've been going back and forth with the Crown for like 8 months about whether or not my client's asthma inhaler would have affected the test, because the officer waited, but he didn't wait 15 minutes. He only waited 5, and it turned into this whole thing about how long you have to wait. And they went and had the lab go experiment with asthma inhalers. And lo and behold, some of them do contain ethanol and do cause false readings. And ultimately what got the Crown to agree to dump the case, because he said, well, I still have a strong impaired. And I said, I'm going to ask 2 questions. Your officer is going to agree with them, and that's going to be the end of your impaired. So if you have, like a lot of symptoms and your officer, for whatever reason, just decides to use the ASD, because a lot of them do, you ask these 2 questions, you're undermining the impaired. You arrested the subject and made the breath demand on the basis of the ASD test result. Without that result, you wouldn't have proceeded with the demand or some variant thereof. If you get them to agree to that, then there's now a whole bunch of reasonable doubt about whether the person was impaired. Basically, the ASD undermines the impaired. And you also want to ask this question in any case where you're trying to challenge the officer's reliance on the device because of a malfunction or a contamination issue. And then this Zacharias decision, a lot of you probably know because it's more in like the warrant context, where it talks about how if something is unlawfully obtained and it forms the basis of a later authorization, then you don't go through the 24-2 process, it just goes away. And that's how it used to be when it came to ASD test results. And then for some reason, courts started going into 24-2 on whether or not the ASD test result was admissible, which is dumb. Um, and not the practice we use in BC still, thankfully. But Zacharias is the answer to that, which is as soon as you remove that ASD test result from the equation, they no longer have grounds for the breath demand. And you go into 24-2, obviously, on the breath demand, and the breath sample may still go in any event, but you're not doing a separate 24-2 analysis of whether they can whether the ASD fail reading is admissible for the purposes of showing the officer had grounds to make the breath demand. It's a little bit silly. Um, so uh, these two cases here, McConaughey and Bensmiller, are good cases to have in these other circumstances about recent drinks. McConaughey is a case. The BC Supreme Court citation, it also went to the Court of Appeal, but the Court of Appeal decision is about an entirely different point, and they just like 3 paragraphs where they're like, no, there's no legal error there. So, but the actual explanation of it comes from the Supreme Court decision. Basically, Mr. McConaughey said his last drink was 5 minutes ago. The officer waited 10. That wasn't good enough. And then Mr. Bensmiller pulls out of the parking lot at the time the pub was closed. The officer pulls him over and he's like, have you been drinking? He's like, yeah, lots. How you know they've been drinking a lot when they admit that. And the officer didn't delay the test. And the court said that to imagine in such circumstances that some alcohol had not been consumed within the preceding 15 to 20 minutes seems to me to be akin to willful blindness. And then open liquor in the vehicle, there's tons of cases on when an officer finds open liquor, whether it's before or after the ASD. Because remember, they've already agreed, or you're going to get them to agree that everything they did subsequent to the ASD depended on what the ASD result was. So if they find open liquor even after they get the fail reading, they've got to clarify, was this consumed within the last 15 minutes? We have a case here in BC. It's an unreported decision where the officer finds an abandoned car in the snow and sees footprints, and Mr. Thompson is peeing in the woods. He comes back to the car. The officer smells liquor, reads an ASD demand, gets the fail reading, and then is searching the car before having it impounded and finds an open concealed beer under the driver's seat, and he does nothing about it. And the court says, that he had to go back and ask him about what he'd originally said about that 2 hours. Did that include any sips from that beer? Because he knew his grounds for the subsequent events relied on that ASD result. And so that was thrown out. Then we have breath demands, which are based on reasonable grounds. They also are requirements that the demand and samples be as soon as practicable. And the opinion for the breath demand has slightly changed since 2018. Now, it doesn't have to be reasonable grounds that they're impaired or that they are over 80. It's reasonable grounds that their ability is impaired or that they committed an offense under 320.141B. Because that includes being at or over 80 within 2 hours after ceasing to operate the vehicle. So if you have a case where they either skip the ASD or they use the ASD based on a suspicion at the doorstep or something, the fact that they post-driving consumed doesn't impair their opinion like the way it used to. So be careful about that, because a lot of breath demand validity decisions also take place, the pre-2018 ones, in the context of post-driving consumption, and that's no longer a problem for the police. There's a very tiny quote there from a case called Shergill. I just love this case and I provide it to everybody because we had this really great judge, he's retired now, Justice Kent, who would write the law out in super clear ways. And this is like the best articulation you can get of the difference between reasonable grounds and reasonable suspicion. So I basically cite it in every argument. It's cited in every judgment I get because the judges are like, oh, this is good. So it's super helpful, which is why I've included it for you. You don't need to know what reasonable grounds mean because I'm sure you all do. As soon as practicable. This is a term that, like the old forthwith in the criminal code, has caused so much consternation. And the definition has essentially boiled down to reasonably prompt in the circumstances. And so this encompasses things that are necessary and related to the investigation, but are not irrelevant. Like a case I had recently where as soon as practicable was violated because the officer spent like 20 minutes dealing with my client's dog that was in the back of his truck to try and find a dog sitter when he was taking the client in for breath samples. And that's, somebody else could have done that. That could have been dealt with later. The dog would have been fine. It wasn't a hot day or anything. So you have to look at what the officer is doing before they read the breath demand, after they get their fail reading, or after they form their grounds. And also after they read the breath demand, before they get to taking the breath samples. What are they actually doing? And is it necessary steps of the investigation or not? This is the leading case, Vanderbruggen. These are the paragraphs that set it out, and you can see all of those citations there. It's a really great canvas of the law. Lots of appellate cases relied on. And this is basically what's used now as the definition of as soon as practicable in pretty much every decision. So there's your leading authority. When it comes to the breath samples at the detachment, there's also a bunch of criteria that have to be met in order for those to be proper. So they're now set out in the criminal code, which is super helpful. They've got to be received into an approved instrument operated by a qualified technician. And you might think that that just means that the certificate has to say they provided the sample. There actually has to be some evidence somehow that the person blew into the instrument. So there's there's a case where the officer testified. It's called ZMUD, ZMUD. The officer testified that he presented the accused to the qualified technician who had dealings with him. And that was not considered to be evidence that the samples were received directly into the approved instrument. Now, the certificate does say that. So, sometimes judges will rely on the certificate, but, having that evidentiary link is important. So watch out if it's not there, because sometimes you can sneak in a mood issue. There has to be a system blank test, which shows not more than 10. But the weird thing about the blank tests on the instrument is they're actually masked. So anything under 10 is just shown as a 0. So you never actually know how much alcohol was in the instrument when your client blew into it, contaminating it from the alcohol standard tests. The alcohol standard has to be certified by an analyst. Super important that you check your disclosure for the certificates of the analyst. So you'll have your certificate of qualified technician for the breath samples, but you also should be getting 2 documents, certificate of an analyst. And there's 2 because when they take those gas canisters, 2 separate analysts at the RCMP lab will randomly pull 10 out of a lot and test them to make sure that they're giving the expected reading. So you have the double checking of the 2 analysts. So there should be 2 certificates, and those are required to be disclosed to you. Whether they're required to be filed in court is not something the courts are in agreement about very much. Samples have to be taken at least 15 minutes apart. You're probably never going to see them less than 15 minutes because the instrument typically doesn't allow it. The only time you can get less than 15 minutes kind of fudged in there is, do you do daylight savings in Nunavut? Yes. Okay. So daylight savings, if the clock changes, sometimes that can produce weird times on the certificate. And the other circumstance is if you have multiple different time zones. Like I have a case right now where the call was made from one time zone and the investigation took place in a different time zone. Like literally they were right on the border of a time zone change in BC. So sometimes that can produce funky things. And then if there's multiple people providing samples at the same time, like multiple investigations taking place contemporaneously, then you can sometimes get them because they're going to override the instrument's automatic countdown to go back and forth between people. And the results have to agree within 20 milligrams percent once they're rounded down to the nearest multiple of 10. And all of the instruments truncate it, so you'll always see the nearest multiple of 10 rounded down. But the police also have their own criteria for a proper breath test, which you can grill your qualified technician on if there's any issue in your evidence that you see that these things might not have happened. Number one, a face-to-face and uninterrupted observation period of at least 15 minutes before the first sample and between the two samples. Number two, there's also is that it has to be 20 milligrams percent and the successful blank test, diagnostic standard test, and alcohol standard test. So really you're looking at the observation period at the detachment. If you have detachment video, always request it every time. Number one, because sometimes your clients don't look drunk at all, and all the symptoms the officer pretends they saw don't exist, and you can completely undermine their evidence. And number two, 9 times out of 10, your officer is not paying attention during that 15-minute observation period. They're chatting with their colleague who's behind the counter. They're checking things on the computer there. They're flipping through their notebook, scrolling through their phone. They're not watching. And this is required in their training to make sure there is nothing that could interfere with the samples. Um, for the approved instruments, evidence of malfunction is going to be the hardest thing because you basically can't get any disclosure. Thank you, criminal code. You basically just get the certificate, the breath test tickets, the alcohol standard certification, and that's it. But you can sometimes see things in the disclosure that will allow you to make an application to call the qualified technician as a witness. And sometimes you can get the Crown to just agree to call them, maybe make something they said relevant to your charter issue, and then they have to come. And then you can backdoor them in. So look for, read the manual for the instrument the police used. And again, it should be in your law library. If it's not, you can request it as disclosure. If they won't give it to you, you can FOI it. Number two, request the review the status messages for unsuccessful attempts. The qualified technician is supposed to document those, and they appear on the scrolling screen on the instrument, and they're supposed to write them down. Technically, you are entitled to disclosure under the criminal code of any error or exception messages produced by the instrument. So if your client doesn't successfully produce a sample, then they should disclose that. And then examine things on the breath test ticket. Sometimes you'll see a mouth alcohol flag, a third blank check missing, and 3 stars. Those are the most common ones I see. Mouth alcohol flags require the officer to redo the observation period and restart it. And if you get samples that differ by more than 20, they'll take one, and then if the next one's more than 20 apart from it, they'll take a third, and they'll rely on the 2 that are closest to one another. But why did it change? That's the big question. And you can usually get them to agree that the only way that could happen is with mouth alcohol. There's also all sorts of issues you can look at on the alcohol standard, which is why it's important to make sure you're disclosed those certificates, but don't ask for them if you don't get them, because if they don't disclose them to you, then the certificate can't go in. So don't ask for them, but if you get them, look at them. The Crown's getting really good at making sure they provide those things. And so this is the thing I said about alcohol standard certificates and whether or not they need to be filed. BC and Alberta say, yes, it has to be filed as part of the Crown's case. And everywhere else that's considered the issue has said, no, it does not. And I missed a citation here, but also the Saskatchewan Court of Appeal, RIP, they also said, no, it doesn't have to be filed. So it's their one judgment that made me sad in the last year. And you also are entitled to reasonable notice. I'm keeping an eye on the time here. So reasonable notice does not mean a hard deadline, but if you say or find a reason that you wanted to call the qualified technician to cross-examine them and you get the certificates disclosed to you less than 60 days from trial, you're frustrated in your ability to bring the application because it has to be 30 days before trial on 30 days notice to the Crown. So it has to be a minimum of 60 days. There's no statutory authority to truncate that time frame in the criminal code. And so the application, either you can force a Jordan issue by finding your reason to call the qualified technician and then having to have them adjourned for you to give notice, or the trial adjourned for you to give notice, or number 2, the Crown will just stay the 08, or the judge will throw it out if you argue that you didn't get reasonable notice. There's also all sorts of errors that you can spot on certificates. I'm running out of time, so there's sample errors. And like I said, I have like 90 something slides. So the rest of this is going to go into other things, like things you're going to want to canvass with your client that can affect the ESD. and factors where there's qualified technicians as well as refusals and blood samples, which are so rare that you may never deal with them, and some issues with certificate services, and then charter stuff. So I'll leave it there. And like I said, the rest of this will be available. I'll also send out, I have a little like running list of good cases with like a little 1 sentence summary of each of them. I'll send that out too. So you all have all my like what I call my best ever case law directory. Any questions?
That was so amazing. We should have booked you for more time, Kyla. I learned so much. I I don't see anybody else with a question, but I have a question with respect to the temperature of the devices. So in Nunavut, we get down to like below -60, and like freezing skin can happen in seconds sometimes. And so if a roadside test is being applied in those kind of conditions, I guess, like, first of all, what are the authority, or what is the authority that I can cite in that matter? And like, I would imagine having the device outside of a pocket or away from the heater in that situation could cause a false reading. Is that true?
Yes, or it can cause the device to malfunction. So the authority, you would say you would probably want to look at number one, the alcohol test committee recommendations, and then number two, the manual for that specific device, because the manual will say the temperature range in which it can be used, not its internal temperature range as well. So look for that. And yeah, the -60 is definitely outside any of the in which it can be used temperatures for any device I'm aware of. So that'll be fun.
Amazing. Well, I don't want to keep you past our time, but thank you so, so much. And I know that there's a lot of other lawyers who weren't able to make this who are planning on watching the recording. So we really appreciate your time. So from the Law Society of Nunavut and all of us here, thank you.
Thank you.
Okay. Thanks, everybody. Bye.